Welcome everyone to the IAPP web conference, Privacy Beyond Checkmarks, Law 25 and the Evolving Landscape of Canadian Consent, sponsored today by Security and KPMG. My name is Selena, a Programming and Speaker Coordinator here at the IAPP, and I'll be your host for today's program. We'll be getting started with a presentation in just a moment, but before we do, a few program details. Participating in today's web conference will automatically provide IAPP certified privacy professionals, who are the named registrants with 1 CPE credit. A recording of this program and the copy of the slides will be available in your My IAPP account under My Purchases and My Recordings tab within 48 hours. Please feel free to post any questions you have for the panelists at the bottom of your screen in the Q&A area. And now on to our program. I'd like to introduce today's panelists. We are very excited to have Sylvia Kingsmill, who is KPMG's Global Privacy Solutions Lead. She has over 20 years of experience providing privacy risk management advice, serving both the public and private sectors. And I would also like to introduce Manoj Thareja, who is the Data Privacy Tech Enablement Lead for KPMG in the US. He has strategized, operationalized, and managed data risk for C-suite leaders for over 20 years, and now spearheads KPMG's US data protection and privacy technology offerings. And our final panelist I would like to introduce is Rehan Jalil, who is CEO of Security, a provider of data security and privacy software. He has previously served as SVP and GM of Cloud Security at Symantec, and it is a pleasure to have you all speaking here today. I will now hand it over to Sylvia to begin the program.
Thank you very much, Selena. Hello, everyone, and welcome. What a great way to kick off the May 2-4 long weekend here across Canada. I'm absolutely delighted to be with you here this morning. We have a pretty exciting agenda. And what we're going to talk about today is not about Law 25 requirements specifically. We all know that Quebec companies have been gearing up for Law 25 for the September 30th deadline approximately 2 years now. And we're very well aware that the fines and penalties for non-compliance are quite egregious. So what we decided to do is focus more on what you need to do about Law 25. If you're a Quebec entity, just fly under the radar, starting to think about this now, or if you're a mature Canadian company doing business across Canada, getting ready for new federal legislation called C-27, or even if you're a Canadian company that's doing business abroad in Europe, where you would probably most likely have to comply with the GDPR. And much of what we're going to talk about today is inspired by the GDPR. So I'm going to kick things off to provide you a Canadian privacy market update. And obviously the spotlight will be on the legal driver out of Quebec. And I'm going to talk to you about what we believe is to be the 3 key high priority areas that you should start thinking about when it comes to your privacy program design, development, or deployment, wherever you are in your compliance journey. And I'm going to hand it off over to Rehan, who's going to talk to you about the state of the art in privacy ops. And then over to my colleague from KPMG USA, Manoj, who I work very closely with, to talk about the privacy transformation journey. And this is really critical. This is where the rubber hits the road. So if you care about your brand, your reputation, financial risk, and more importantly, if you care about customer loyalty and trust, you're going to learn a lot from us today. Because much of what we're going to talk about around Law 25 will be equally applicable to the pending legislation here across Canada and all the regulatory activity that we've been seeing lately. So with that, over to the next slide, Selena. I've been in this business for almost 20 years. Next slide, Selena. And I've never before seen such market disruption in the world of privacy, which really has required management consultants like myself to not only think about privacy differently, but to deliver privacy differently to our clients. There are many drivers of change that you see up on this slide. And privacy concerns have only risen since last year, fueled by all sorts of media stories around Roe versus Wade, the EU's crackdown on tech giants like Meta, And now with the recent regulatory privacy investigations into OpenAI, not just in Europe, but also here in Canada. So while privacy laws are still playing catch up to technology, by 2024, that's next year around the corner, Gartner predicts that 75% of the world population will have its personal data regulated. That same study also predicts that large companies will spend over 2.5 million annually on privacy. And with the World Economic Forum's Global Risks Report, pretty important report, ranking large-scale cyber attacks and major data breaches among the top 5 risks in the next decade, this will only be amplified by AI. So this leads me to my next market observation, the huge convergence, not just between privacy and security, but also around governance. And now AI governance, which needs to be baked into risk management approaches that need to be tailored for the new digital reality of AI. So this is a real big push, a legal push under privacy laws and here in Canada and around the world to embed privacy and security into new emerging technologies. And Selena, just go back for a second, and to demonstrate that this has been done through industry standards like ISO 31700 is privacy by design, a neat standard developed for privacy engineers, where we really need to start thinking more about privacy by design, proactive risk-based approaches to privacy compliance and having security by default baked into every emerging tech. And so previously it was enough for business just to claim that they were compliant, but really now they're required to operationally track and report on privacy compliance and to prove it. We call this due diligence. And finally, attitudes and expectations for privacy have radically shifted. So over to the next slide, Selena. The digital customer of today is time poor, more privacy aware, and less trusting. Increased demand for data subject rights and expectations about transparency and fairness is driving the need for a differentiated privacy user experience. So we all know since 2018, the GDPR in the EU set a really high bar for the protection of consumer data rights. And the goal of that legislation was to give back control to the data subject. That's me and you, that's me up there on the screen. And the law really takes a human-centric approach to privacy, and that's happening in Canada already. So data processing is always predicated on consent, and it gives customers the ultimate authority to opt out of that consent. And both the data controllers and processors, that's under the GDPR terminologies, have the shared responsibility to respect user rights and to ensure the customer data is processed fairly, it's lawful, and it's transparent, and that the data is safeguarded throughout the data life cycle. So when you take all of these rules together and bake it into a privacy program, it really boils down to consent and preference management and data subject access rights, which I'm going to refer to as DSAR for short. And many forward-thinking companies that we're working with lately, they recognize the advantages of bringing all this together into a centralized privacy user experience, and it includes notices, cookies, consent management, and DSAR, and in a very automated way, which Rohan and Manoj will talk to you about. And really what that does, it creates operational efficiencies and it gets you to compliance. So this is super important, knowing that the enforcement priorities of regulators here in Canada and around the world have always been and will continue to focus on data subject rights. Over to the next slide, please. So the first jurisdiction in Canada to have enacted stricter GDPR style requirements that focus on respecting customer user rights is Quebec. And we all know that full compliance is going to be, it's around the corner. It's September 30th. Data portability kicks in the year after that. But much of what you do by way of your compliance readiness activities for Quebec will also hold true for C27, which is the federal legislation that is pending. It's currently stuck in second reading, so hopefully we will have momentum there. But really, the takeaway here is that there is a lot of legal reform in Canada to modernize our outdated Canadian rules and regulations. And really, there's a lot of activity happening out west, in Ontario and across the board. So it's really important to start thinking about enhancements to your privacy program activities and turning over to the next slide, Selena, I wanted to walk you through some of the Law 25 compliance themes that we're seeing out of Quebec. Most of this shouldn't be a surprise. Much of this already exists in existing private sector federal PIPEDA legislation, but a lot of this has now a heightened level of rigor. So there's mandatory privacy impact assessments, there's cross-border transfer rules, there is privacy by design and default already in the GDPR and being done by companies as a best practice. And there's individual rights. And I think that is central to the conversation we're going to have today, because in our opinion, the most important aspect of Law 25 and C27 and all the regulatory activity globally really is centered around enforcing user rights. So what does this mean? This means that companies must be able to seamlessly honor DSAR requests. And at a tactical level, when an individual exercises their privacy rights and requests to access or modify their personal data, they submit a DSAR request. This includes access, deletion, do not sell, market requests, and also under Law 25, users have rights on how you're permitted to use their data. Contextual use of data is super important and high risk. So if a user in your platform opts out of processing 10 of the things you do with their data, your organization needs to be able to identify that customer, which may be a single entity in your data set, and enforce such a withdrawal mechanism that may only apply to specific attributes of their record for a single process. So this level of granularity can only be implemented if you understand your data set as a first, and where your sensitive data lies in an app or a database, in order for you to prove that you have consent in the first place. So this is what it comes down to, having a solid consent management strategy, and this needs to be coupled with data discovery and data mapping, because that is really foundational to the consent management strategy that you have, coupled with any DSAR processing, and Manoj will talk to you about that later in the presentation. Or the next slide, Celia. So all of this can become quite complex if it's done out of order. Given that in the work that we're doing, we're noticing a huge upward spike in DSAR requests. Our clients have an added layer of complexity because much of this is a manual process. The last study that we looked at was in 2018, published by the IPP, around Excel spreadsheets being used to do things, namely data mapping, where only 30% of companies were doing that in an automated way. And so if you look at what's happening in the United States, for example, 54% of privacy requests come through states lacking privacy protections or law on their books. And so, oh, and by the way, the cost of access and deletion requests alone between 2021 and 22 have more than doubled. So this trend is extremely telling about the evolving market trend across the customer base and what this will mean for Canadian companies, irrespective of the size or maturity, given the changing regulatory landscape of Law 25 and pending C27. Next slide, please. So now is a time for organizations to calibrate the status of their privacy program for 2023 and beyond. Mature companies who have to comply with GDPR or are highly regulated would have started this a long time ago, and they just have to look at the delta of what they have to enhance to have their privacy program compliant and complying with best practices. But really, it's about the privacy office having visibility into the operational aspects of privacy compliance and to understand what's actually happening at the data level and across the tech stack and across the customer base that I've just talked to you about. So really, we've been advocating a holistic and mature privacy program, which is based on people, process, governance, and technology, using a risk-based approach. So I highlighted for you what we believe are high priority, high stake areas to tackle in the order that Manoj will talk about, which is inventory, data mapping, DSAR, and consent management. And Manoj will talk to you about crawl, walk, run approaches to that. It's very successful and very effective. But as a first step, really, understanding what data you have, where it comes from, how it's being used, and what legal basis exists to prove that you can actually collect it in the first place, use it and store it. As a first, the inventory data map aspect through data discovery is table stakes. So And it's also really critical to ensure that your business knows how to implement the advice that the privacy office is providing. So there's a huge opportunity to accelerate and automate these compliance activities to alleviate the operational burden on the business. And in consulting speak, we call this privacy tech enablement or privacy ops, which is what my next speaker, Rahan, is going to talk to you about. So over to you, Rahan.
Sylvia, thank you so very much. Very enlightening. Really enjoyed you explaining the requirements itself and how they need to be addressed. In my section, what I'm going to try to do is to go over the very specific requirements within the law and how you may about actually addressing it in much more automated fashion. What is the state of the art, which, for other regulations globally, actually organizations are actually utilizing, and those similar state of the art can be utilized for the Law 25 also. Going to the next slide. So these are, you'll see on the top, these are the various different requirements as per the law. These are different, and we're going to go step by step on these requirements. For obvious reasons, data governance is the very first thing. And why is that? Because privacy actually is primarily about the data that represents a human, their personal information, their activities, their consent, and so forth. So within the organization, it's a fundamental requirement to actually have a clarity on what kind of data is there, what is sensitive, where is it sitting. There has to be a DPO, and the DPO would have the capability to actually have that clarity for the organization, as well as all the retention policies have to be there. So what do you do for that? Because data is spread across all different places in an organization, and it is all jumbled up. The sensitive information about individuals is all jumbled up with your non-sensitive information, and that's very typical across most organizations. So an automated discovery process has to be there. The technology has to enable that can actually scan your data and actually can highlight to say, where is the PII, where is the sensitive information that ties to this particular law, and it can give you a complete view versus doing some old method of asking people around and about the sensitive information, which would just never work as compared to automatically discovering it. The second important aspect of the governance, if you would want to automate many of the things which we're going to talk about, is to understand where is the data of a specific individual inside your organization, inside your data systems, your SaaS apps, your databases, your cloud, your non-cloud, where is the data of one specific individual? Because privacy is all about the right of one individual at a time. And that's something done with automatic creation of something called people data graph. Because once you have people data graph, you can ask about any specific person's data and you will get the answer. Going on to the next slide, this can actually also help with the data mapping, where once you've discovered the data, all the practices that go along, the organization behavior around the data often can be in your travel knowledge. It'd be sitting in some place in your processes. It has to fuse together, and it has to be automated. Where the discovery is automated, all the controls around the data, the security controls, which is also a requirement in section 3.1, 3.2 and all, is actually also enabling for you to put it all together as part of your data mapping exercises, and they go kind of hand in hand. Using this information, you can have all kinds of governance controls. What does it mean by that? Is the data secure? Is it protected? Baseline. Who can access to it? Who should not have access to it, and if they're getting access to it? And that control information also has to be extracted automatically so that you're not guessing and you have that information available. Going on to the next slide, as Sylvia had highlighted, giving individuals their right. Data legally belongs to the individual. It may be inside the organization, but it belongs to the individual and only be utilized based on what consent is being acquired. And keeping that in mind, the entire process of individual rights giving the individual rights to the individuals has to be automated. What do you mean by that? From the collection of requests, identification, verification, all the way to figuring out where the data is inside the organization, using people data graphs, automation layer, and then using what's called robotic automation to actually go find the data, fetch it, bring it to a workbench, and having the ability to your teams or KPMG, if they're helping you, to actually enable the completion of each subject request in a lot more automated fashion and reliable fashion. And that has to be typically be done with the technology, and that's for many other laws. It's being done with the help of technology. And you can also go check out privacycenter.cloud, in which you can see very easily. You can actually get it going, get started with the front end creation, collection of the requests, and for the implementation, Manoj will be talking after my time slot to actually how to actually really operationalize at the enterprise level. Going on to the next slide. It's also in the law, in the relevant sections highlighted here, 3.4 to 3.8 sections of the law, that the breach, if there is ever a breach of the data and the privacy breach, individuals have to be notified. And there is very specific guidelines for it. The real issue is that you have to, first of all, understand who's impacted. Let's say if you have one structured data system or even a structured data system, how do you know how many people are inside it?